All right, good evening, everyone. Please take your seats and come to order. Welcome, everyone, to the City of Annapolis Board of Appeals special meeting, regular meeting for November 6th, 2024. This meeting is being broadcast on the City of Annapolis YouTube channel. The agenda for tonight's meeting may be found on the City of Annapolis website. The agenda contains links to the City of Annapolis YouTube channel, the comment form that you need to fill out if you want to comment or testify in the case, and to the city's database for information about the cases that you'll hear tonight. Let me remind everyone that communication with anyone, with any member of the board, has to go through the comment form, or if you're a party to the case, it has to go through liaison to the board, Kim Consolway. No one should ever contact any member of the board directly about any case before the board. So we'll begin with a roll call. Kim, please.
Mr. Gallagher?
Yes.
Dr. Chen?
Present.
Mr. Hector?
Here.
Mr. Walsh?
Present.
Mr. Zazali?
Yes, here.
All five tonight, Mr. Chairman.
Thank you. So we clearly have a forum. I think everyone's had a chance to see the agenda. There's been a request from Mr. Dales, counsel for the applicants, in the second and third items for us to move his cases to the beginning of the agenda because he needs to appear this evening before the Beverage Control Board. So that would bump him ahead of 418 3rd Street. Is there someone here from 418 3rd Street? No? Okay. All right, so we'll grant Mr. Dale's request and we'll take up his matters first. We'll request that Mr. Dales reciprocate that courtesy by making these presentations as concise as possible.
Thank you, Mr. Chairman.
So we'll proceed in our usual order with Mr. Dale's cases.
Move to protect the agenda as submitted.
Yeah, right. So are there any, other than that change, are there any other changes or corrections to the agenda?
No.
Is there a motion?
Yep.
Motion to accept as is.
Second. All in favor?
Aye.
Aye.
Thank you. And we have minutes to take up for the minutes of October 1st, 2024. Any corrections or additions to the minutes?
No.
No motion. I move that the October 1st meeting minutes be approved. Second.
All in favor?
Aye.
All right, thank you. So we will move directly then to special exception 24009. The address of the subject properties is 12, 14, 16, 18 Market Space. It's the Iron Rooster, as I'm sure you all know. Special exception for major modification to special exception SE 2015-016 for an expansion to the standard restaurant. The applicant previously obtained approval from the board under special exception 2021-05, which has expired. The applicant's asking for the same relief again for the expansion from 208 seats to 239 seats. Ms. Burke, I believe that's your case. Is there anything you'd like to tell us by way of introduction?
Yes, Kim Burke, Planning and Zoning. Do you want to do the variance too at the same time, or are you doing them separate?
Yeah, why don't we do the variance too? That would be variance 24017. Also the Iron Rooster at Market Space. Variance requested to the rear yard setback from 30 feet to 0 feet for replacement of existing rear egress stairs. Again, the applicant previously obtained approval from the board under variance 2015-06, which has expired, and the applicant's asking for essentially the same relief. So go ahead.
Right, so both of these were previously approved with the city. They did go out for re-review There were no additional comments. It's still in compliance with the comprehensive plan. And I guess the only two conditions of approval that we would be adding to the special exception that are different than the previous conditions from which will be the same, well, those conditions will continue on with this new one, are the replacement of a portion of a curb that was taken out when they installed their grease trap that was never reinstalled. And one of the awnings that is currently in place did not have HPC approval. So the HPC reviewer would like to have them apply for that and have that approved prior to any building permits for the special exception.
All right.
And I guess in the other difference is the original variance, I think, asked for 10 feet from the rear yard. And I just revised that to say 0 feet, because if you look at the stairway exhibit on page A2 of the variance package, it comes up taller than 4 feet in the back. So technically anything above 4 feet, it's just to cover the whole staircase, which needs to be there as an egress.
Okay.
But other than that, we have no public comments. The sign was posted. We have affidavits of the mailings, and we received no public comments, and the city still continues to support this project.
All right, Mr. Dales?
Mr. Chairman, members of the board, those of you who were here when we initially applied for this special exception variance, certainly I think most of you were here when we went for the renewal, and it's been more than 2 years. We can't extend it any further. And we'll briefly say the reason that we've not been able to put this into effect is a building code issue. We've had to open up the firewalls between these spaces at 12, 14, 16, and 18. And the building code and the city have required us to get reciprocal easements for each of the owners. So 4 different owners, and each of them had to give each other access to be able to repair the fire alarm systems on either side in order for us to open up those firewalls. Took a long time to get everybody to agree on the language that they could all sign on. We have it now, and we're ready to move forward. So we're just coming back asking for exactly the same thing that was approved by the board before. Staff report's accurate, and we agree to the new conditions. And I'll leave it there just for questions.
All right. Thank you. I'm not sure who best answer this one, but I noted in the staff report, Ms. Burke, that the sector study limits identical uses in adjacent buildings. How is that addressed here?
Say that again?
You noted in the staff report that the sector study limits identical uses in adjacent buildings. I take it that's your view when it's all one operation, that it should be viewed as a single building?
Greg saw what, yes.
All right.
Sorry, yes.
Yeah.
Yeah, it is the same.
All right. Any other questions from the board?
I just have one. The 2 a.m. and the amplified music, that was a condition that we this as a right to the.
We do have a liquor license approval for this expanded space. We just took the same license that was in 12 and 14 and expanded it, and we have to go and redo that as well for expiration.
All right, you're not asking for a condition?
No.
Married.
Nope.
Sorry.
Did you get it all?
Yeah.
Sort of?
Mr. Dales, I think since the last special exception you had before us, it's been a new but fairly consistent practice of the board to add a new condition on the special exception regarding enforcement. Do you have any problem with that?
No, I think I was here for the meeting where we first did that,
Okay.
so I'm
good.
familiar.
All right. Excellent. Okay. All right, if there are no other questions, we'll close the record on this. We'll hear the case for variance for 418 3rd Street. And then my suggestion would be that we deliberate the applications before we move on to the appeals matters. All right, thank you, Mr. Dales.
Thank you, Mr. Chairman, members of the board. Very much appreciate the agenda change, and if the other applicants here, thank you to them as well.
All right, variance for 24016, 418 3rd Street. Variance requested to rear yard setback from 30 feet to 14 and a half feet for the installation of a second-story deck on the existing house. Ms. Burke, would you like to tell us what we need to know about that?
Yeah, so this 418 3rd Street has pretty much been I think this house was constructed in the early 1900s. Well, it was, originally, I think it was a bakery, and it's been a commercial use, and it's been in this place. It predates zoning code, it predates critical area. So anything that they would want to do to the rear of this house would require a variance. They're asking for a pretty modestly sized deck. The bulk of this property is impervious right now, so there's no new impervious to put this deck on. They're actually removing some of the gravel in other parts of this property, but currently where this deck is, there is I think it's a mixture of paver and gravel underneath. So they want to have this second-story deck, and I think it won't be pervious, so that underneath will also be able to be a patio.
Okay.
But it's lot coverage today. So based on the fact that this house predates zoning code, it's been here since the early 1900s, that we support a modest size. I think it's like 10 feet in depth. It's a pretty modest sized deck so that they can use their what little backyard they have. This has also been through site design review with the Eastport Civic Association Architectural Review Committee, and they have approved this also. It was posted. I did receive the photo of the posted sign and the affidavit, and we didn't get any comments for this when it went through the ECA for that review or for this variance.
Okay. Any question? And so there's no one representing the applicant present tonight?
Apparently not.
Okay.
That's a first.
Yeah. They obviously knew about it because the sign is in their front yard.
That's just an indication of their confidence in you. All right, questions from the board or council?
I do have a couple of questions, but I'm not sure who to ask since the
Well,
applicant
you're
I think
asking
you'll
me,
have to ask
Nadine.
Kim.
is not here, but I note in the staff report that the applicant just desires more livable space. Do you know why they consider a deck? Is that like a term of art, or?
I don't know. I mean, it's definitely a deck. I mean, it's the underneath will be covered, so to a patio area. So I can't answer that question.
And then you can probably discuss the tree.
Oh, I do. I can talk about that because our arborist did review this, and they did remove a tree without a permit. So part of the condition of this approval is that they apply for an after-the-fact tree removal permit and mitigate for that tree prior to getting the permit to build this deck.
And do you know why they illegally removed a tree?
No, I don't. Honestly, a lot of people don't realize that they need a permit to remove a tree, because it really depends on where you live and where, if you're in the critical area or not, or if it's in the front of your house. I honestly don't know exactly where the tree was. I'm going to assume was in the front of the property, because the house is basically encompassing the entire rear of the lot. But they are aware of that, and I think are working through that right now.
Okay, and I assume that the interior being renovated?
Yes,
And you,
because it was an office, so now it's
Right.
going to be a residential.
right, and you've, planning and zoning has seen the interior plans?
Yes,
to
they
that?
have plans, they have those, the interior permits are in right now with the changes to the exterior also, which were approved by the ECA.
And it is going to be a single
Oh, yes,
residence
yes.
home? Okay, thank you.
Anyone else?
Mr. Chairman, just a quick question. Kim, I don't mean to put you on the spot, but I'm reading through the submission. I read it earlier today, too. And it's the age-old question we have whenever we have this issue come up, which is the hardship versus inconvenience. And I'm having a little trouble seeing the hardship here. Is it
Well, the
fact that
hardship
it was
is
built
the-
in 1908 and
Yeah, I mean, the house right now is only, I don't have my glasses, it's like 22 feet from the rear of the property. It's always a 30-foot setback, so any
would require?
any deck would require a variance, and this was originally a commercial property.
Yeah.
So now she's changing it into a residential, in a residential neighborhood, a residentially zoned district, which obviously is also, you know, we support that change of use to the residential. And it's not a huge deck. It's not like it's, you know, it's only
No.
10 feet deep.
10 by 30. Thank you.
Yeah, I had the same question, but since the applicant is not here, I wasn't sure how to answer that question.
Mr. Hector?
Kim, they're not going to use this as rental property, are they?
No, she's living there right now
Okay.
while with the renovations going, as far as I know.
Okay.
Mr. Zazali?
Are you aware of any other second-story decks in this zone, in the proximity there, that are similar to this property?
I mean, I know places in Eastport, other houses do have second-story decks, but most of them, well, I haven't done a variance for one because these houses aren't so close to the rear yard as this one.
Yeah, I do agree that 10 feet is,
So, Kim, if I understand it, we're not expanding the nonconformance? We're not pushing further into the setbacks than?
Well, it wouldn't be a non-conformance because we're asking for a variance.
Okay. We're not going beyond the extent to which they've already pressed into the setback.
Right, I mean, yes, they're not doing any exterior changes to this house. I mean, other than like the facade and, you know,
And what are the changes in pervious and lot coverage?
so they're removing a good portion of, I think it's on one of these pages. They're removing, if you look on the Messick plan, they're taking out, if you see existing conditions plan, there's that gravel symbol.
Yeah,
It says all existing gravel to
Okay,
be
good,
removed. So they're removing a good bit of impervious. I mean, it was a commercial building, so the whole front of this is a parking
and they're
lot.
doing stormwater management?
They are not required to do stormwater management
They're not required?
because they're doing, I mean, technically, removing impervious is a form of stormwater management.
Right.
And they are, I don't know if it's, and they are also planting trees. They have a whole planting
What's the
plan.
mitigation requirement for cutting down that tree?
I'm not sure what size it was, but it's based on size. Brian is handling it. I think they have to plant back one tree, if I remember correctly.
Okay. Okay. And I mean, don't they have an awfully large asphalt driveway and parking pad?
Yes, they do. We have recommended that they remove a portion of it, but we can't force them to.
Well,
They are removing all the gravel on the side of their lot.
how
which is
much
a
did you
significant-
recommend they remove?
I think it was just a ECA comment about potentially removing some driveway, and then we just we didn't give a specific number, because it wasn't a requirement, it was just a suggestion.
Okay.
Because they are making an effort by removing everything to the left of the house and making it lawn, which was all gravel.
Right. But this is a missed opportunity to treat some stormwater, I think.
Yeah, anytime you're just renovating in an existing building like this, I mean, by the code, you're not required to do stormwater.
We understand.
But they are reducing their lot coverage, which technically is stormwater management, any reduction in lot coverage. I mean, if you reduce 50%, then that is your stormwater management requirement, but I don't think that's possible here.
Any other questions?
I did stumble across one more. The 14.6 rear yard setback, can you comment on how consistent that is in the zone? Are there other lots nearby that are equal to or less than that setback?
This house is further back. If you look at like Google Earth, or this building is set further back than any other building on this street,
Okay.
significantly.
And the posting was all done and none?
Yes.
And no comments,
No.
nobody came forward? Okay.
Any other questions? All right, we'll close the record on this application, and we will turn to deliberations on the applications that we've heard over the last few minutes. Why don't we start with this one? It's fresh in our minds. Anyone like to start?
Fundamentally, I think in Eastport, there are challenges to those lots, for sure.
I agree.
And I was sort of baiting the city employee, but she didn't take it. 14.6 is not exactly tight. We've had much tighter approvals of variances for construction in other properties in that regard. And 10 feet does strike a tone of minimalist ask, right? Like beyond 10 feet, you can't even have a table or a chair or get around it. So I think on many of those points, it strikes as a reasonable request. And I think bending further deliberation warrants consideration for approval.
Yeah, I see no, yeah, I agree. I think it's a minimal request, and it's, I would have loved to have had a little bit more justification on why they need a deck there and why that's absolutely necessary. But I see no reason to shoot it down either.
I do encourage the chair to continue to push the above more than necessary
Yeah.
clause within
I
our
have some
charter.
thoughts on that.
Yeah.
Go ahead, Dr. Shen.
Yeah, my only comment is on the hardship front. I always get kind of hung up on that if it's just for enjoyment purposes. So that would be my only comment.
Yeah, I think this is a variance that should be granted. But I also think that in applying our criteria, particularly hardship and minimum necessary, that we have some balancing to do against the interests at stake here. And I think we also, in the code, have a good deal of discretion when it comes to conditioning the issuance of a variance. So the couple of things that occurred to me are, do we want to require something in the way of stormwater management? Do we want to require enhanced mitigation, particularly in light of the removal of a tree without permit? Or do we want to require some additional reduction in impervious by way of some part of that expansive driveway and parking pad? Any thoughts on that?
Well, I mean, yes, I think it's a laudable goal to try to push that into every piece of where our authority allows it. But I also do recognize that they have 6,000 square feet and they're removing 2,000, right? So they're chopping out a lot. And if they don't like our decision, they can appeal that, right? They could, but we could come up with something that, I would be open to the proposal of a condition.
Well, just to make the point on the removal without a permit, I would suggest that we double whatever the mitigation requirement is.
Two trees.
Anybody have any thoughts on the driveway? Stormwater is awfully complicated to get into in
Well,
the condition.
the driveway because I live in Eastport, so I know where this property is. And I think it's right next to Ruth Chris, isn't it, or near it? So
Yeah, it's a couple doors down.
yeah, so parking is really an issue right there. So I think that the resident should be able to have off-street parking, because I guess there's no room behind the house
No,
to have a garage or anything. So I would be sensitive to that, even though I would love to shrink the size.
And we
of the
may need to
driveway.
park there for the next boat show. All right, well, I'd be satisfied if we double the mitigation for the tree.
I would like, not to drag this on, but in the criteria A, a particular hardship to the owner results as distinguished from a mere inconvenience. The hardship is they can build no deck. That is a hardship.
Yeah.
They're not coming in and say, we'd like a deck a little bigger, which is an inconvenience. The hardship exists because they can build no deck. And that, to me, is a uniquely particular hardship.
Yeah.
So,
We're not, no one's disputing that.
okay, just wanted to help.
Yeah,
Okay.
cool.
Yeah,
So is there a motion to approve the application subject to an additional condition for doubling
I'll go ahead and
the
do this.
mitigation?
brilliant.
I move to approve variance 2024-00016, based on the record, the staff report, and evidence given in this hearing.
All in favor?
Aye.
All right. Thank you, Kim. Now we'll turn to Iron Rooster. Anyone like to start on that?
Do you want to take them separately or together?
Let's take them together.
Okay.
Any volunteers?
Mr. Walsh?
Thank you, Mr. Zali. Yes, I think, I feel comfortable standing on our previous approval, and with the additional conditions that you've placed on, I believe was the special exception, have those additional conditions, Kim?
I placed them on the special exception.
Special exception, yeah, 15 and 16. The plan was sound and approved by us a couple of years ago, and I think that I can appreciate having 4 different owners trying to sign off on building issues could cause a little bit of a consternation. So I think the evidence is still good that this is a project worthy of having a special exception. As to the variance, I think the 4 requirements of this variance are met as well with the original plan. I think that certainly, Kim, the external stairway,
Right, it's for egress.
yeah, should be a part of that new criteria, new condition. So overall, I think it does meet the standards of both the special exception and the variance.
I think you should just get on the record what the language of our enforcement.
Yeah,
I don't know that we have it handy, but
I might. Let me see. Yeah, the new enforcement condition that we are proposing, I think you have it anyway, Kim, but I'll read it for the record. Any resident of Annapolis who believes that he or she is adversely affected by a failure of the applicant or a successor to comply with one or more conditions set forth herein may file a written complaint with the Director of Planning and Zoning specifying the grounds of the complaint. Within 60 days of receipt of such complaint, the director shall issue and provide a copy to the complainant a written determination as to whether or not a condition has been violated and what steps the applicant must take to correct a violation. A failure of the director to issue such a determination within 60 days shall be deemed a determination that no violation has occurred. The applicant and the complainant shall have the right, pursuant to the City of Annapolis Code of Ordinances, Title 21.30.020A, to appeal any such determination by the director to this Board of Appeals. determination by the director or the Board of Appeals of a decision that a violation has occurred and has not been corrected as required by the director shall invalidate this special exception in its entirety. Is there a motion?
Mr. Chairman, I move that, and as the matter of special exception 2024-0009 and variance 2024-00016 have satisfied the, based on the preponderance of the evidence of the record, have satisfied the.
1-7.
I'm sorry? 27, excuse me. Yeah, it's 27. That satisfied the requirements to the granting of a special exception and also a variance.
Second.
All in favor?
Aye.
All right.
All right, thank you very much. Iron Rooster. We're going to move on to our status conference in Appeal 2024-002, 518 6th Street, because Dr. Chen has some connections to the owner or the site. She wishes to recuse herself, and will certainly honor that decision on her part. Sure, that would be good. All right, this is a status conference in Appeal 2402, 518 6th Street. Appeal challenging the determination of the director to approve the site design plan for the redevelopment of a property at 518 6th Street. We have Ms. Corrales for the director, as Mr. Gill, is it?
I'm sorry, what did you say, sir?
Your name, sir?
Yes, Grant Gill, G-I-L.
Yep. For the applicant, for the appellants.
For the appellant.
Is there anyone for the applicant? All right, are you
Thank you.
formally appearing, sir, or just observing?
Sorry, Mr. Mayor, I cannot hear you.
Would you identify yourself, please?
My name is Lawrence Goldstein. I represent Gerald Hyman, who's the owner of the property. He's not the appellant or the appellate.
He's the applicant.
He's the applicant, yes, sir.
All right. And have you filed an appearance in the case?
I'm vaguely familiar with the motion to dismiss
Okay.
Mr. Gallagher.
Sir, I suggest you read the board's rules if you're going to appear in the case. And the board's rules require that you file a notice of appearance. We're happy to accommodate you tonight, but I urge you to do that promptly if you want to continue to appear in the case. Can you hear me?
He says you need to file a notice of appearance in order to show up, but they will accommodate you tonight.
There is a notice of appearance from the first conference.
All right, thank you. Thank you. All right, what are we going to do to make sure you can hear?
Well, sir, your microphone's actually a bit far away from me. I think it's,
Oh, sorry, all right.
it might be easier.
Good. Okay, thank you. Is that better?
I just
Substantially.
want to hear what they say.
Can you hear me now?
I can hear you very well now. Thank you.
Thanks. Good. All right, so we have our appearances. There's a motion to dismiss pending, filed by the director. We have briefs from the appellants. And so the agenda tonight is to get to argument on the motion to dismiss. The board may interrupt with questions during the argument, or they may choose to save their questions to the end of each presentation. That's up to you. I've asked the parties particularly to address the issue of whether the 30-day deadline for appeals should be considered jurisdictional. That is, if it's not met, there's nothing the board can do. We have no jurisdiction in the case. Or if that 30-day deadline should be considered more in the nature of a statute of limitations, where there could be equitable reasons for extending it. So I hope you'll address that and keep your arguments as brief as you can. But before we start, let's see if we're all on the same page. So, looking at the papers that have been filed so far, the site design plan, which is the first item mentioned in the notice of appeal, was approved some time ago. And the appeal was filed in
July of 2020.
July, more than a year or 2 years after the site design plan. So there's no argument, is there, Mr. Giel, that the appellants had no way of knowing that the site design plan had been approved, that had been posted?
No, sir, we are only arguing with regards to minor modifications.
All right, so
Our definition of what is a minor modification within the context of the whole development may be different than what the city argues, but what we are saying, and if the board would determine what the scope of that is that we're challenging minor modifications only. We're not challenging the original approval.
good, that helps. So the minor modifications were also approved more than 30 days before the day of the appeal. And the argument is that because you didn't know and had no way of knowing about those modifications until they were made public, and you filed within that 30 days from the time you knew, then you're within a reasonable interpretation of 30-day rule. Have I got that right?
That is substantively correct.
Okay. So is there any dispute that the appeal was filed within 30 days of the time that notice of the approval of the minor modifications became public?
The minor modifications did not have to be
I
public.
understand that. But the question is there any dispute that the notice of appeal came within 30 days of the time that they were made public?
No, there's no dispute.
Okay, that's very helpful too. Thank you. So the issue is whether the deadline for appealing the modifications is 30 days or 30 days from the date that the appellants knew or should have known. We're agreed on that, yeah?
Yes.
Well, and in addition to that, it's our position that the minor modifications that were made were things that related back to the initial published plan from 2021. So the issues that were brought up and approved were published in 2021, and they decided not to appeal until the revised approved plan was published.
Till a different approved plan was published.
Right.
Yeah, I get it.
Mr. Chairman, could I ask you to just restate that again for me, please, Jessica?
Sure. It is our position that the minor modifications that were made in the revised plans relate back to things that were covered in the initial plan that was published back in 2021.
So it's your contention that minor modifications, when they became public, really were made with the original plan, subsequent to the original plan?
There are modifications to the original plan,
In
and
21.
those items could have been appealed. Those topics could have been appealed initially.
At that time, if it was known?
Correct. There was no appeal to the initial published in, I think it was the summertime of 2021.
Okay, that's, at least that clarifies that.
All right, well, so let's move on with the,
Just on that, Mr. Walsh's point, something was published, but was there a decision at that point that was appealable? Was there an action that was appealable, or was it simply a presentation?
The plan was approved and put online so everyone could see
Okay,
and
an
could appeal
approved
it.
plan was put
Correct.
online, not just plans. but-
Correct. The approved
Okay.
plan was put online, published.
Okay, so, Mr. Goldstein, anything from you at this point?
Yeah, shut me up if I'm out of line here, please. It's the applicant's position that there were continuing opportunities for the neighbors to know what was going on. Every time an application was submitted for a modification, that was part of these minor modifications. Eastport Civic Association was duly advised, and there was feedback back to the director or acting director of planning and zoning, and that there was this letter agreement that's referred to in the record that contained a list of the modifications. Anything that happened at that property from the day it was first appraised by the lender was known to neighbors. Mr. Hyman severely injured his ankle and was in the hospital for 4 surgeries. He gave me the key to the property, which was from the beginning a tear-down property. It was extremely dangerous to walk in there. I had the job of allowing the appraiser to go through the property. Within 5 minutes of my arrival, an inspector from the Anne Arundel County Office of Planning and Zoning appeared, who had been called by a neighbor.
Mr. Goldstein, these appeals are on the record, so if you're going to refer to facts, they need to be facts that are in the record. Do you have are you representing that all of this back and forth between the applicant and the city all was made public on the city's website in real time?
No, I cannot say that. The city itself indicates it wasn't on the city's website.
Okay, all right, thank you. All right, let's move ahead with the argument.
Mr. Gallagher, if I may speak briefly to both of these points that people.
Why don't you just address them in your
Yeah, sure, I can
argument?
do it in the argument, that's fine.
Go ahead.
Oh, I didn't know if you want to start with me or, so.
You've got the burden, so
Yeah, of course.
off you go.
So this is the situation as we see it. There was a plan that was approved. There was no appeal brought to that plan. There is no appeal currently being brought to that plan. There were then, as the city and the applicant suggest, a series of conversations between them that were not put in the administrative record, were not even attached to this motion to dismiss.
Can I interrupt? It was my understanding that we were just talking about the jurisdiction issue tonight. Is that
Yeah.
not accurate?
That's what we're doing. If you
We're doing
think,
that, but I think this needs to be applied, this needs to be addressed to the extent that you're considering whether or not the minor modifications were or were not granted notice to the appellants. If there's any factual matter,
you can refer to the record on that.
well, I'm trying to refer,
Okay.
I'm trying
All
to refer to the record. There's nothing in the record, to my knowledge, that indicates that there was any public notice of this. And even to the extent that the board would consider exhibits, which, as we had stated in our response to the motion to dismiss, is improper in a motion to dismiss hearing. You should assume the facts in the light most favorable to the non-movement.
No, in this case, the only facts we consider are the facts in the record.
Yeah, so the exhibits that were put, even the exhibits put before the board by the city do not show what is being claimed.
That's a fair assertion.
So what we have is minor modifications that at some point in 2021 were theoretically approved. But until 2024, were not known to anyone other than the applicant and the city. The appellants moved to get these documents once they had constructive knowledge that the building being constructed was different than what was in the plan, and they went about learning of that themselves, that the building as constructed was different than what they saw. There was some back and forth as to whether or not they could get those documents that I don't think is particularly relevant here, except to say that eventually the city decided to put the revised revised plan and the minor modifications on the eTrackit website, which would be the minimal threshold for notice in our position. And once we got that notice, once we reviewed those minor modifications in that revised plan, it was our contention that what we saw there was substantially different than the original plan, substantially different enough that it wouldn't legally constitute minor modifications, and would in fact be a substantial deviation that was outside of the director's authority to grant. Whether or not that is in fact legally true or factually true is something that can be determined at a substantive hearing later. But the assertion that we have there is that that's what happened. And we had that 30-day time window between the 25th of June and the 17th of July, wherein we then appealed to this Board of Appeals. The question is whether or not that appeal is timely. Our argument is summarized, because you told me to keep it brief, and I'm going to try, I know it's going to be late for people, is that the motion to dismiss presented by the city is insufficient. It does not demonstrate that there is in fact any legal basis for the board not to consider this. It cites the city code and the 30-day rule without any actual analysis as to any case law to suggest that that 30-day rule is a jurisdictional question as opposed to a statute of limitations issue. And then it goes through the individual portions of our claim after it presents its general broad argument that the entire matter should be dismissed, and says as to these individual elements of the claim, this should be dismissed for one reason or another. We have addressed the various individual portions of the motion to dismiss broadly by saying that what we are alleging is only with regards to minor modifications. It does not relate back to the original plan. To the extent that anything incidentally relates back to the initial plan, we cede such an argument. We look only at the minor modifications. To the extent that the initial plan may have been illegal itself, we don't argue anything with regards to any original illegality, only to any modified alleged illegality that arose from the minor modifications in the revised plan. The claims that this should be before the Building Board of Appeals are unsubstantiated because the Building Board of Appeals itself had already decided that it does not concern itself with the two elements that are cited by the city, and that is a matter before the board that has already been resolved on procedural grounds. And the common law as it relates to a statute of limitations matter is such that a reviewing body can cite any equitable reason, which is a very broad term in this area of the law, to allow a matter to be heard outside the statute of limitations, which in this case is 30 days. The board had asked us to address specifically Kim versus Comptroller of the Treasury, which we did. We opened up the case. We summarized it. We assumed that the board is generally familiar with it. To the extent that the board is not familiar with it, unfortunately, I don't have my internet at the moment. But I would broadly state that Kim versus Comptroller was an appellate court case that concerned whether or not the appellate court could determine the substantive ruling of a circuit court decision. And it had decided this in the context.
I think that was a tax court decision.
Sorry, Maryland tax court, yes. But the substantive holding in our mind is that as the appellate court stated at that time, in a circumstance where it is looking at an actual circuit court, a judicial decision, it can't look at that decision past 30 days. It can't intercede on a previous judicial decision. Where instead the decision that it is reviewing, or any court is reviewing is not itself a judicial action, but is instead legislative, quasi-legislative, quasi-judicial, ministerial, et cetera, then the rules for a judicial review would apply instead. And a judicial review is, in that court's view, a matter of a statute of limitations as opposed to a jurisdictional issue. Now, I am unfamiliar with any case that specifically speaks to the Annapolis Board of Appeals, but I view the administrative process of looking at a lower level administrative decision as being the equivalent of an administrative version of your judicial review, which is that the upper level administrative body looks at the lower level administrative body, looks to articulation, looks to substantial evidence, looks to legal error, looks to arbitrariness and caprice, and then gives deference to that lower level agency, determines whether or not there's any legal or factual error, overturns if so, does not overturn if not. But that the mechanism for that is functionally identical to a judicial review. And Kim states that in that circumstance, equitable relief can apply, just like it could apply for a judicial review of a court if the court were reviewing, for instance, this Board of Appeals decision, because at the conclusion of the administrative process, one could petition for judicial review before the circuit court. We then cited Shell Oil Company versus Supervisor of Assessments of Prince George's County, which explained additionally what appellate jurisdiction is, and I would quote the relevant portion from our supplemental memorandum. The exercise of appellate jurisdiction requires a prior action by some judicial authority or prior exercise of judicial power, as is regularly recognized by the courts of this country. And courts have held that review of the decision of an administrative agency is an exercise of original jurisdiction and not appellate jurisdiction. What we have here is, despite the label of appeal, despite the name Board of Appeals, not an appellate court appellate review of a circuit court decision. It is a 30-day judicial review styled analysis of a lower level decision, which incorporates in the city code very similar language to what the common law is for judicial review. Again, arbitrariness, substantial evidence, legal error, arbitrariness and capriciousness. And as a result, because of the fact that it is uncontested before this board, because there is nothing in the administrative record or even in the exhibits presented by the city that would suggest that the appellants had any way of knowing that these minor modifications were in fact granted or what the substance of those minor modifications were, and because as soon as we figured out about this, within that 30-day window, we reviewed that revised plan, decided that we thought there was a legal error, and then appealed to this board. We think that it is appropriate for this board to look at the June 25th, 2024 date as the time in which the decision was functionally available to be appealed. Because if the board were to reason otherwise, it would essentially mean that all a person would need to do in this city is to not tell anyone what they're doing, wait for 31 days, then publish it, and then say, you can't do anything about it. You should have been calling us every single day.
All right, let me interrupt you there.
Yes.
So your argument to this point is that looking at the law, the cases, and the way they've looked at a 30-day limit on filing appeals, they've broken cases into kind of two categories. One, they decide that because of the relationship between the reviewing body and the original decision maker, that it's a review of an administrative decision, and the reviewing body exercises original jurisdiction, right? And so the standard of review is like a statute of limitations.
Yes, I'm sorry, I should be saying this for the record, yes, as opposed to nodding. Yes.
And then the other side of it is if it's more like an appellate review, a review by a superior court of an inferior court, then the 30-day rule is an absolute
deadline.
Okay.
And in that circumstance, I would add that for the circuit court's decisions do not run until such time as they are entered onto the docket and given to parties, so the parties always have that 30-day notice.
Yeah. Okay, so if we accept that, I think until 2020, it was pretty clear that this board in hearing appeals was exercising original jurisdiction. We had full hearings with witnesses and evidence, and but in 2020, the rules changed. The council changed the standard of review in appeals of decisions by the director to this board to review on the record, which is what reviewing courts do, as you know. And moreover, they described the standard that this board applies when it exercises that review as whether the director's decision was arbitrary and capricious or whether it was unsupported by the facts or the law.
Yes.
That seems to me to suggest that it was, or it may have been, the intention of the council to vest this board with appellate review type standard rather than original jurisdiction review. Why isn't that the better interpretation of the code?
Because I think when you look at a legislative analysis, first you look to the clear legislative intent as stated, then you look to the legislative intent as it relates to Maryland law generally, and you assume that the Maryland legislature in question is trying to determine something that is going to be legally sufficient. And then you look, if there is no stated intent, there might be legal sufficiency and it's unclear as to what they otherwise intended, to the implied language that they have there. And the language that they have there, and you said it yourself, is you're looking at arbitrariness and caprice, you're looking at substantial evidence. But that is the standard for a circuit court as well in judicial review. A judicial review action, the standard of review is exactly what we have in our opening memorandum. I, in fact, copied it from one of my memoranda to a circuit court for a standard of review. It's exactly what I say to a circuit court. And if the appellate court has previously decided with regards to appellate versus original jurisdiction that a judicial review action by the court is, in fact, statute of limitations, I don't see why the legislature would be trying to limit specifically the Board of Appeals in a manner that is contrary to stated appellate case law and otherwise in line with what that appellate case law said as it relates to circuit courts.
Is there anything in state law or in the city code that would limit the authority of the council to decide what our standard of review should be?
Well, I don't think that there's anything that would limit a legislature to determine the laws outside of, something like strict scrutiny if we're looking at constitutional issues. But if the legislature were to have determined and specifically stated, the Board of Appeals shall only exercise appellate jurisdiction as decided in Kim versus Comptroller, then one could say that it's the clear legislative intent to implement that. But
okay, so that's your argument on which standard should apply. You have sort of a belt and suspenders argument that even if the board exercises appellate jurisdiction standard, there's still room for an equitable adjustment to the 30-day limit. Why don't you tell us about that?
Sure. This is, I think that the board never needs to reach this question because I think that Kim is actually quite clear and in our favor. But where is that case law? I want to make sure I quote it properly. Crofton Partners versus Anne Arundel County. Implicit in the requirement that an appeal lies only from a final decision, however, are the correlative requirements that an aggrieved party know that the decision has been made and that the decision is final. As to finality, one could determine that something is final because it says so in the actual document itself, or maybe there is a code provision that states that a particular type of decision is final. We don't dispute that the minor modifications would be a final decision, so we aren't confused as to that matter. But the critical element of that with regards to this equitable relief, even if there's an appellate jurisdiction, is the knowledge component. If it is not possible to know, then I don't see how any potential appellant could move forward to the board. And I said before in the opening argument that this would frustrate the purpose of appellate review within the administrative apparatus of Annapolis. That any person operating in the government in any area that is enacting some sort of decision could theoretically just hide the documents, keep it between themselves and the applicant, say nothing to anyone, flagrantly violate, and we'll set aside the question of whether or not there is a public notice requirement for this. Assume there's a public notice requirement for some other action. Assume that this is a full-on major site plan and that public notice has to go forward, and that we're thinking of the original plan right now, the original STP. City meets with the applicant, says nothing to anyone else, approves the plan in silence, sits on it for 31 days, then publishes it. Then people say, you didn't tell us about that, you needed to do so, it said so in the code right there. And they say, sorry, you can't appeal, you missed your deadline. If you can't know about the decision, there is no way to exercise your appellate rights. And I think it is uncontested in this matter that what is before this board in the administrative record, and even before this board with the exhibits of the city presented, show that there was no way for a person to know that this decision had been made at the time that it had been made. A person could keep calling up every single day, presumably, and asking the city to give them the document. But all the city would need to do is not listen to them, wait for 30 days. Say, the Maryland Public Information Act requires us to respond within 30 days, and then on day 31, they present it, and they say, oh, it's now 31 days, you can't appeal it. Even within the confines of the MPIA, you would be completely bound.
But you've made your point, I think. All right, Ms. Corrice, you've see the problem.
I do, and some of the questions that you brought up were some of the arguments that we had, so I don't want to repeat and waste anyone's time, but it's our position that the appeal is untimely and the board does not have jurisdiction to hear this appeal. It's our position that this is an appeal. It says so in the code, it's called the Board of Appeals, and the city code through the city council gave the Board of Appeals limited jurisdiction on what they can hear. And that includes appeals that are filed 30 days after the decision is complained of, which we say is the original site plan that was approved back in 2021 that was published. And that anything that was subsequently published were minor modifications and there was no requirement to publish them. The board gets their authority directly from the code, and it is limited intentionally by the language of the code from the city council. That was the intent. And jurisdiction is not waivable. It's not like the statute of limitations that you can waive. This is not a statute of limitations issue. The 30 days have passed, and so there's no jurisdiction for the board to hear this appeal. When it comes to Kim versus Comptroller, that's a distinguishable case. I think it's clear that it's obviously dealing with premature petitions for judicial review of an administrative decision to circuit court. That's not the same here. And in that case in particular, their circuit court stayed their action until they got a final response from the administrative decision. It had nothing to do with jurisdiction of the circuit court. And here, this is a jurisdiction issue. You can't, the 30 days is mandatory time limit. It says they may file an appeal within 30 days. That's not waivable. Late filings cannot be heard by the board. We contend just in our motion to dismiss, and I don't want to go back to what our arguments are there, but there is a large portion of it saying that the things that change were minor modifications related back and not relevant. Council talked about that a little bit. The appellant also argues that the board can provide equitable relief, and we don't agree with that. The code says what the Board of Appeals can do when they make their decision. They can affirm, reverse, wholly or in part, modify the order, requirement, decision, or termination by the board.
No, we're not going there. Don't worry about that.
Okay. So I just want to make sure that's off the record. I don't think it is logical, reasonable, and allowable to have, if the board finds that it's a statute of limitations, that they waive that and provide equitable relief. I think that's outside the scope of what the board can provide. So, as I said before, June 2021, the plan was published. Just as an example, some of the things that were in there were the design, the setback, the square footage, all of those things could have been appealed the first time. Those are things they're appealing now.
No,
That was in the-
but they're different now.
They are minor modifications, which is allowed by the code for the director to make without publishing.
I don't think there's a dispute about that either, that he's allowed to do it. It's just, can you appeal when you don't have notice of it?
Well, they could have appealed, they could have appealed the first time around in June 2021.
They didn't have notice of the changes then.
Well, but if they had an issue with the size it was gonna be, the front setback, they could have done an appeal then. They decided not to. Minor changes, if it goes from, this is just an example, 100 to 200, if they didn't like the 100, they could have said something about it. They waited 2 years, over 2 years, to file anything when they were well aware that that project was happening. They could have, if they had concerns and questions about it and they didn't want to file appeal with the plan, but they wanted information about it, they could have done a PIA request and gotten information about it if they had questions about it, but they chose to do nothing. And the things that they're complaining about with all are in the purview of minor modifications allowed by the director. And I disagree with council's position about what the Building Board of Appeals said, but there are issues that they brought up that are not in the jurisdiction of the Board of Appeals, and they went to the Building Board of Appeals for that. So,
Okay, let me ask you this.
Sure.
If the board was of the view that the Maryland courts have adopted this analysis, Mr. Gill's interpretation of the Kim case, this kind of looks like the administrative review that he would suggest gets original jurisdiction standard. So what, if we think that the council wanted to change that and make it an appellate review standard, what is the authority of the council to do that?
they would have to draft an ordinance to try to expand the purview of what they want the Board of Appeals to cover.
Even if it's completely different from what the state courts believe is
Well,
the
that
proper.
would have to go through the Office of Law, and obviously there might be some tweaks to talk about it. But if they want to do something, they would have to come up with legislation and work with the Office of Law to see if it's feasible. Without doing research on whether it's feasible or not, I can't tell you if it would pass or not. But if they wanted to change it, they have the process and power to try to change it.
Okay, so if the board goes with your interpretation of the Kim case, Mr. Gill tells us that the Crofton Partners case allows for an exception even there when it would be impossible for the appellant to know of the decision appealed from. Awful lot of common sense to that, and fairness, fundamental fairness. Is it really the city's position that they have no right to appeal something they didn't know about and had no way of knowing about?
The city's position would be the alternative position that was in our initial motion to dismiss. So if you recall, our first was it was untimely and should be dismissed. And then our alternative is that some of the items that were appealed were not proper. So we would narrow the scope of what we would argue.
Well, let's just focus on the last set of approved modifications.
There's not an argument. The city can't argue that they knew or should have known that the modifications were done when they were. They were published whatever that date was, and that was their first notice. But we do contend that minor modifications are within the scope of the director and don't have to be published.
Yeah, I understand. Do you have a question?
I do. I would like to touch on the subject of the rights of the planning director to allow for, to facilitate, to participate in minor modifications. Does any modification, minor modification, this one or others that are happening in the director's purview, are they decisions? Or Or is it your contention that minor modifications are further development, refining, detailing of an otherwise already approved decision?
In this case, they're revisions to already made decisions. I can't say it's always like that, but revisions were made to things that were previously approved. So they're just taking something that was already published and approved and tweaking it.
And when did that take place, Jessica?
And what?
When did that take place?
That was a long process. I don't have the timeline, I don't think, in front of me.
And since we're only on the record facts here, I can only ask this, and you can, I don't know, during those conversations that were not public or tweaking, as in your words, if requests, adds, adjustments, otherwise known as minor modifications, were to stray beyond the scope of minor modifications, what would the planning director's obligation be at that point?
Those have to be published.
And where is that line? What?
It's in I don't have that code section with me, but there's a section in the code that talks about major modifications versus minor modifications and what the process is you have to get major modifications essentially re-looked at and reapproved.
Right.
Minor modifications, you don't have to go through that process.
But it's not your position that minor modifications can't be appealed where they do know about them?
They can be appealed.
Yeah, okay.
Yeah.
So a minor modification is a decision, and it is a decision to allow something to be modified.
That's what she just agreed.
Yes.
Yeah, I mean, it's semantics, right? A minor modification is a change to something that was already approved, already a decision. So it's a revised decision. But the subject matter relates back to the original. It's not a brand new topic that's being added and decided, if that makes sense.
Anything else, Jessica, that you think we need to hear?
No, that's it.
Good.
So I have it straight, Jessica. So June 2021, the original decision was made, published. Subsequent to that, and by you said a few moments ago, a long process, subsequent issued minor modifications made to that plan. Is that correct?
Yeah, excuse me, in 2021, the summer of 2021, the plan was approved.
Mm-hmm.
There were some ongoing, and then in October 2021, there were some additional stipulations that were published and put on the record. And then it wasn't until July of 2023, the revised permit drawings were actually prepared and referred to as the final revision.
And that was published?
That was not published until recently.
Until June of, got it right here.
24.
June 24.
Yes.
So in essence, the minor modifications were never published until June of 2024.
Right, because they were minor
I
modifications.
know, and they relate back to the original
Right.
decision. I get
That's
your
our
argument on
position,
that. On the jurisdictional issue, if you could clarify for me, I read your brief. How is it that we don't have jurisdiction when the Building Board of Appeals does?
That was for one of the appeal issues was talking about, I think, a site survey and a stop work order, and that had gone before the Building Board of Appeals. So that was under their purview.
Mm-hmm. But not these minor modifications themselves, the ones that were subsequently published, the most recent minor modifications?
No, the minor modifications are within the purview of what the Board of Appeals would hear.
At no point, Mr. Gill, at no point there was, you've made the argument that there's constructive notice, didn't arrive until June 24th.
Well,
There was no effort, no communication, nothing. from any of the appellants to the city asking about the plan, the house, before it began construction?
So the original plan, and there's, we move forward with the assumption that the original plan was properly granted, even if there would otherwise be some argument, had it been appealed, that whatever was in the original plan might have been illegal. The original plan moved forward, people didn't appeal it, they didn't have any issue with the original plan as presented at that time. Once building construction started and people looked at it and they went, that doesn't look like what it should look like. Then they saw that and they reached out to the city, to the planning board, DPZ. And they said, hey, what's going on with this? Again, there was a bit of back and forth with regards to whether or not they could get those documents. Then DBZ published the documents and said, your MPIA request is mooted now, we've published the documents. Then we got the document. So we had constructive notice that something looked different whenever there was something being built, but we didn't have constructive or actual notice that what was being built was in accordance with any revised plan until we saw the revised plan, which we got on the 25th.
So the core of your argument is that your theory on equitability is that the director's decision was capricious, arbitrary, without
We would
proper
think it would be
notice.
legally in error.
Legal in error.
Well, arbitrariness and capriciousness is very often, in my opinion, merged with legal error.
You're right.
Because arbitrariness, the court
by
looks at as though,
definition.
oh, if it's illegal, obviously it's also arbitrary. But technically, there could be a circumstance where something is legal but arbitrary if you only apply it to one party and not the other. Either way, yes, we argue that it's illegal. And I think it's important to note that within the scope of the review, and I'm reminded of what the chair said to me right at the beginning, we have the burden of proof for the appeal itself, but as it relates to a motion to dismiss, the non-moving party is the one that has the favorable factual inferences in favor. So the burden of proof as it relates to a motion to dismiss is on the movement. And factual assumptions are what the non-movement says. So this notion that minor modifications were just minor, he could do that without notice, there wasn't any issue, they relate back, that's the city's factual assertion. The appellant's factual assertion is that the minor modifications did not relate back, they were different in kind than the original plan. The way they were different in kind violated bulk regulations in the city code. Because the director is not allowed to approve minor modifications that run afoul of the law, those minor modifications therefore were not minor anymore. They became de facto major modifications. And as a result, it needed to be put forward because somebody would then look at that and go, oh, you're doing something that is potentially contrary to the city code. So whether or not minor modifications were in fact minor or just minor is at this stage in our position something that should be assumed in our favor, that the minor modifications in question were illegal until at a later date the city proves otherwise. And as a result, we say this stuff did need to be presented because it was different in kind, and it was different in kind in the manner that was legally insufficient.
Thank you, Mr. Chairman.
Thank you. Mr. Goldstein?
The minor modifications are marked clearly on the current copies of the plat, which have been available since the e-track it, to allege that they would support the declaration of a violation is a little far out. There's a little bit of side stuff that is essential. This application is 7 years old. This applicant has been trying to get a house built for
Mr. Goldstein,
7 years.
Mr. Goldstein, our review is limited to the record. You did have an opportunity to file a brief. I don't believe you've done that. I want to give you the courtesy of an opportunity to respond to these arguments, but let's stick to the arguments, the legal arguments.
Well, I think the manner of appellate authority, et cetera, has been well discussed by both sides. I would only add to that that this is a statutory entity. It's created by Anne Arundel County Code, which then sends it to be subjected to the state of Maryland Land Use Code. And that is the final authority on what type of entity it is. It says a Board of Appeals may hear or decide appeals when it is alleged there is an error in any order, requirement, decision, determination made by an administrative officer or unit. The administrative officer was the director of planning and zoning. At the time, most of those modifications were made. That was Dr. Sally Nash.
All right.
One major point that is not of record, it's merely a question. Where is the most harm going to be done? If you dismiss this action, they file a case in the circuit court and it gets finished a lot quicker. If you do not dismiss the action, there will be a hearing on the applicant, the appellant, making his case as to whether the permit should be granted.
I assure you we understand that.
And they would also have to show that there was sufficient equitable grounds to extend the time to consider this matter before the board. Not that if there's equitable grounds, we have a right to consider. We don't know whether there's equitable grounds. We don't know who's being hurt here. Is the applicant going to suffer some loss if this case is dismissed?
Thank you, Mr. Goldstein. So we've heard the arguments. You've had a chance to ask questions. Cheryl, as counsel for the board, during our deliberations, we may ask you for your advice on these legal issues, but are there any questions you have for the parties before we close the argument session? Okay. Anything else before we close and deliberate the motion to dismiss? All right, so we'll consider the hearing closed, and I suggest we move right into the deliberations while it's fresh in our minds. This complicated legal issue, we've read the briefs. I think there are plausible arguments to go either way. Certainly the courts have suggested in other contexts that aren't directly applicable that this kind of an arrangement we have typically would be viewed as original jurisdiction. There'll be a statute of limitations. We could waive it or adjust it for equitable reasons if we thought there was unfairness. But also, we don't know. There are a couple of distinguished members of the council here who might be able to tell us, but we're not going to ask them what was intended in terms of did they intend to change that standard in the 1920 changes. And then we have a plausible argument from the appellants that even if we are under the appellate review standard, which means that you can't really adjust it, that you can really adjust it if there are strong equitable reasons. So that's where we are. I'd love to hear from counsel. Would that be useful to you? Cheryl?
Well, I think what was said during the arguments.
Mike.
Sorry. What was said during the arguments the city said that minor modifications do not have to be published, but the city also said that minor modifications can be appealed. And so here, once, I believe the facts are, once the minor modifications were published, that they appealed.
Right.
So, I mean, it seems to me that the appeal would be timely because minor modifications can be appealed. And they were not made available until years after, the original plans, even though, I mean, I get, it's kind of a two-sided where it was stated that it was in the original plan back in 2021, so therefore it's not something that was really a change, and they could have appealed it then, but then also saying that minor modifications can be appealed, and they finally made the minor modifications available publicly, and the appeal was taken, I believe, within 30 days of that. So I think that's it. But
I hear that whole argument, and I keep landing on the notion that their argument is not that they wanted to appeal the minor modification. Their argument is that the modifications were not minor.
I think that's an alternative. I think that was.
No, I don't.
But to further my point, and I'm not trying to make an argument either way, I'm stating that site design plans are complex. They are full of decisions, interpretation of the code, application of that code to a site-specific to meet the best requirements of the appellant or the plan review, and so on and so forth. And then when you reach that point, I would make the argument, and since we have not had those minor modifications have not been presented to us yet. Right. We have no opinion on whether they were minor or not minor.
That's right. We don't.
We don't. We only have a testimony that they were. Right.
Right.
And then we have anecdotal hearsay evidence that people observed something being built that purported to not match in a manner that was not minor. Right? Or are they saying, because I remember the original case, they said it was much higher out of the ground than the original drawing, all kinds of speculation. And those are just, as a builder engineer, none of that is relevant because it's what's on the plans, right? A decision, if an inspector comes out and allows a building to be built or structure to be built that is different and approves it, it's different than what's on the approved plans, that is the decision that gets appealed. You approve something that you should not have.
But I mean, that's the case here. The decision for us is whether we get to the point of deciding whether it was a minor modification.
And we can't do that because we don't know what they were.
Well, that would be the next stage of the
We're just deciding if it's timely.
Then there'd be another hearing on that.
And my opinion swung, to be honest, when I asked the question, is the ordinary business of fine-tuning an otherwise already approved site plan, is that ordinary business, or are those lots of individual decisions to which each one is subject to appeal?
That would be the analysis, part of the analysis we'd get to in the next phase if we allow the case to go forward.
Yep.
Gentlemen?
I mean, if those decisions are paint colors, and those are not, but they're not. We assume they're not at this point.
I find the city, our attorneys, I hadn't thought of those terms, but it kind of crystallized. If the argument is minor modifications subject to appeal, one has to know what to appeal. If it's a strict 30-day appeal window, then a publication of some sort should have been made when the minor modifications were finally agreed to at its finality, when the plans were done and the minor modifications were approved by the director. I take the view that,
But,
go
to
ahead.
interrupt you, but minor decisions on a construction site happen all the time at the purview and discretion of the local inspector. They deviate from the documents in small and large ways all the time, right? And if 30 days were to pass from that point, and some aggrieved neighbor noticed that something has changed, but it was decided in the field with the inspector, but 30 days had gone by, how would we approach that?
But here you've got a collection of changes, all of which are accumulated in a new revised design plan that's approved.
But the city,
And that's what they're
the
appealing.
city contains, it's substantively the same plan, only minor modifications.
That would be for us to decide if we don't dismiss the case.
Yeah, I get, to me, it's the notice issue, when the modifications should have been made available, at least the ones that were approved by the director, not talking about the city inspector in
So
the
what
field
we'd be
making those
saying
on-the-spot
is-
decisions.
I want to pursue this a little further. So is it our argument that every site plan or building permit that now is approved, that gets tweaked, that does not require a revision, that falls under minor modification, shall always be published and held for 30 days for comments and public review?
Well, there's nothing about holding 30 days for comments.
Just move, you can move on. Okay, I hear
You
you.
can move on at your own risk.
Okay.
But, I mean, I think what you're saying, Mike, and I
It's a burden, but-
tend to agree with you, is that if the director is making a decision and he wants to know that that decision's not going to be changed, he ought to put the notice of the decision out where the public can see it. And he'll know within 30 days whether anybody objects to it.
Well,
And that, I mean, it doesn't seem
How
to be.
minor do those decisions have to be published?
Depends, well, if they're minor and he doesn't care about insulating himself from an appeal, then he doesn't publish them.
well, I mean, we said earlier that there is a code provision that says minor modifications do not have to be published.
That was my.
Right, and so
that's
that-
probably to save the burden on the planning department.
Right. So really, the other answer might have been that they can't be appealed. But that wasn't the answer. And maybe the city can explain, because if they're not published, then how would they be appealed?
I believe the code is silent. It doesn't specifically say
Oh,
whether or not. I think the code is silent. I apologize. I looked at my brief. I don't see a section in there. It says proactively or does allow for, does not allow for it. It just talks about it, as it does not need to be published if it's minor.
okay, and does the director normally publish minor modifications?
I cannot answer that. I don't know.
I mean, we're not going to get into, no, I withdraw what I was going to say. I don't think there's a well-articulated or at least well-followed policy about what gets put up on the website when.
Well, it's clear that they're not obligated to.
It's clear that they're not obligated to.
So if they're not obligated to, does that afford them protection and relief from the appeals? I think what it does, though, is it says, if you don't do it, you can't rely on the 30-day as your cover.
Right, that's right. But so there's no, I mean, there are two ways we can go. One of them, go with the city, says, we're sorry, but even if you didn't know that this decision was made, it's more than 30 days, you can't appeal it. Or we can go, there's some basis in the law for saying that that's really not fair. That when an appellate, if there's no contest that this decision that's being made is something that's appealable, that it's really not fair to say they can't appeal it unless they do within 30 days when they had no knowledge or way of knowing. That's really the decision for us.
And what is in the best interest for all parties? The city,
Exactly.
the applicant, the neighbor, the
And
appeal.
Cheryl, correct me if I'm wrong, but I think there's plausible legal reasons for going either way. It's a question that's not clear in the law.
I think that's right. Oops. I think that's right.
So if we approve motion to dismiss, it moves right out of here to the next round.
No, it'll move to the next phase in front of, if we approve the motion to dismiss, they'll go right to court.
Right, and if we deny the motion to dismiss and we allow the applicant to present why they feel it's not minor decisions, and we disagree, we would be right back to the motion to dismiss. It functionally would have been the same thing as if we dismissed. But if we agree they were not minor, then the applicant has to reapply, repost, everything. Is that correct?
Right, well, in one instance, the court would be reviewing the motion to dismiss. But in the second scenario, the court would be reviewing, if somebody took it up, the decision you all made on the substantive issues.
And it would come
We
back.
haven't gotten to the substantive issues.
If we dismissed and that was wrong, it would come back to us. They wouldn't have to start again, I don't think.
The judicial review.
I'm sorry, I'm going to object to the city there. I don't have a problem with you asking the city something during your deliberations, but the record is closed. She shouldn't be able to reference
I was just
something
going to
to you.
explain judicial review because it sounded like there was some.
Yeah,
And that's what the
let's not
board's
get into
counsel
that.
would
Thank
determine.
you.
All right.
This is deliberation, sorry. I shouldn't
Oh,
have.
I see, gotcha.
I know we're all solidly well-opinioned folks on this board, but I would respectfully afford the opportunity for the chair to be clear on what your thoughts are.
I think it's a very difficult case. I think that the law seems clear, that it's a cutoff, but it doesn't seem fair to me. And there's some case law that says when it's fundamentally unfair to hold someone to a deadline when they had no way of knowing they're up against a deadline, that you should fix that problem.
And in a world where the Board of Appeals writes city code, if it said 30 days or from date of publication.
That would be great. Or the date that they knew or should have known would be fine too. If they had actual knowledge, I'd hold them to that. If they would have had actual knowledge, had they been diligent, I'd hold them to that. And we could put that in a ruling if that's what we're saying. If that's what
A
we're saying.
long list of recommendations.
All right. Let's see. Is there a motion with respect to either approving or denying the motion to dismiss?
I would move that the motion to dismiss be denied.
Is there-
Second.
All in favor?
Aye.
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 Okay.
3-1.
All right. Motion to dismiss is denied. And we'll move forward. So let's think about what that looks like.
Can I ask a clarifying question?
Yeah, sure.
Are all of the arguments in the appeal going forward or just the minor modifications argument?
Just the minor modification.
Okay. I just wanted to make sure I was clear.
I have my own question with regards to that.
Go ahead.
The parties have differing opinions as to what constitutes minor modifications and what the definition of that is. So are you permitting the various counts put forward and then determining to the extent?
You advised us, which I think I described, I hope I described it accurately before, that there was a set of plans approved.
Yes, sorry, okay, I think I understand that we're in agreement
And
that
that
we're
was
not
posted.
challenging the original.
That was
plan.
posted.
Because I'm
And
not challenging.
that's what you're appealing from.
Yes, I'm appealing minor modifications only.
And that's what we're going to move on to next.
Yes.
I think it might be helpful because I would like to know, and you let us know if we can do this, if there's going to be an exchange of what items you are saying, because I think you have like a list of 11. Which ones you are saying are minor modification?
Isn't the
Do we want to do that right now, or?
Isn't the issue of whether
Yeah.
the thing that was approved and published in July or June or whatever it was, is that thing a minor modification or not? And if it is a minor modification, was it a proper minor modification. Is that
So-
right?
So the items that we contend were for building board of appeals, those are out? Or are we re-arguing?
No, we're not re-arguing.
Okay. I just want to be clear.
No, whether a permit that was issued
Okay.
was proper or not. The question's limited to what's in that new approved set of plans. That's
Okay.
different from what's in the site design plan. Is that a proper modification?
Sorry, so my understanding then is that you're granting the dismissal of number 8 and 9, I think is the number. No, not 8 and 9.
I have it.
5 and 6.
We're agree, yeah,
Items
we're,
5 and 6 for the Building Board of Appeals. We don't believe that something should be before the board, but that's the city's argument that items 5 and 6 should have been before the Building Board of Appeals.
So that's out.
So we're asking if you're granting the dismissal of 5 and 6, or,
I don't have them in front of me. Let me see if, no, I don't have them in front of me. The only thing that is not dismissed is the appeal of the site design, revised site design plan that was published in July.
We're fundamentally waiving the 30-day.
Right, it's a partial. What we're doing is, it doesn't really matter, I think. Because we're going to limit the issue on appeal.
if I may propose to the board, to the extent that we have anything discussing items 5 and 6 and whether or not council wants to come to an agreement or not, we can have a subsequent motion from the board for a limitation of its original denial.
Right.
But for now, the board can just grant a general denial, and we don't have to get into the legal weeds of,
Right.
because we have an argument that that's not a building
Right.
board of appeals thing, but the city argues that it is.
So we're going to have a new scheduling order, and it will say that what's left in the case is the appeal of the last decision that was published, the last collection of modifications. And we need a schedule to do that. Are you guys going to need to work out between you
I'm
any
sure
more
we-
questions about what the content of the record
I'm
is?
sure we can, I'm sure we can do that, but I'm just noting, it's odd that I'm arguing for opposing counsel. I'm just noting that in our position, items 5 and 6 are part of the review of the minor modifications, and in the city's position, they are not. And the question that I think we're trying to present is whether or not this is a motion to deny the motion to dismiss on all counts except 5 and 6, or to deny the motion to dismiss entirely, and then there's a subsequent argument about 5 and 6. And I just don't think that that is properly clarified for me with regards to a scheduling order.
Why don't you two,
I think that we should meet offline and try to see if there's issues that we can agree are no longer
Send me-
on
send
point
me-
versus,
send me a paragraph as to what you should be, the
Okay.
definition of the issue that's left on appeal.
Okay.
okay, when do you want that by?
Is a week good?
Yes,
That's fine.
And then that will go into the scheduling order.
okay.
And then you also need to see if you have any differences on what the record consists of, if that hasn't been worked out.
Well, I mean, part of what this dispute about what the record consists of is what was going to come subsequent to this motion to dismiss, is that we think that there are things that should be in the administrative record that weren't.
Well, let me say this about the record. This record review is new. We've only had a couple of cases. We're still kind of working our way through it. The idea is that, and it's particularly important, I think, for the director, is that the record will consist of whatever information the director had when he made the decision. In the past, I may have described that as that he relied on it. That was wrong. If he had information in front of him when he made the decision that he didn't rely on, that's part of the record too, because it's part of the arbitrary and capricious argument whether he should have relied on it or not. So from the point of view of the director, if I was a director, I would be expansive. I wouldn't want to have, for example, a record that lacked some important authority on a subject that I knew was going to be. You get what I mean?
Yeah, it's, you want the exhibits essentially that we would use to prove our case in the record, so that we're not introducing new things while we're at the hearing.
That's right.
Yeah.
All right, so,
I'm sorry, I want to know on my end, what we initially had part of our appeal about was that there are things that were missing from the record. And my understanding was that subsequent to a hearing on the motion to dismiss, if the board were to deny that motion to dismiss, it would have a subsequent hearing to determine whether or not there were errors in the record. So.
the record is still open.
Okay,
And I leave it to you guys to work it out.
Okay.
But the final determination is what the director says in the record.
perhaps we can work it out and we'll talk about that
I mean,
with council.
it would be helpful to the director for you to advise the director on what you think should have been in the record. And the director will decide whether that's part of the record.
And we might not need a hearing. So, yeah, we'll talk about that, and I understand.
In terms of when we get to the merits on this, so we'll have a scheduling order, one would hope, in a couple of weeks. Let's see. That would be toward the end of the month. There's no way we're going to hear this in December. January. Do we have any idea what our agenda looks like for January, Kim?
No, we have some things, but I'm not sure when, no. I think our major stuff will probably happen after January with the holidays and everything.
Why don't we tentatively think about doing it in January, at the regular meeting in January, which would be January 7th. And Kim, that's going to take some time. So you might, for planning purposes in January, if we have other things that have to be heard in January, we ought to think about doing them at the special meeting.
Let's keep this one in person.
Sorry?
Let's keep this one in person.
Yes, right.
Yeah.
Because, and I won't be able to make the supplemental meeting, so if we do,
So you're okay with starting something new virtual if necessary?
yeah, we can do some
Okay.
variances or special exceptions at the virtual meeting
Okay.
in the middle of January.
So January 7th would be the hearing on the merits?
Yeah, and it's not going to be an evidentiary hearing. You guys will have worked that out. We'll have a record in front of us. You'll have filed briefs that will have references to the record and the law. We'll hear your arguments and we'll decide.
Are we gonna get deadlines for the revised briefs that we have to submit?
Yes. So if we're going to have a scheduling order before.
Can we move it later, because I think the briefing schedule is gonna be the
gonna be hard.
holidays.
It's
If
going to
we're
be
gonna
hard,
do it.
especially if you contemplate us having concurrent briefs, that's a different matter. But if you expect us to have an opening and then reply.
So, but
Yeah.
I'm going to miss the February meeting. So do you really want to put it off till March?
I don't want to put it off to any day.
I just don't know if it's really
Feasible.
reasonable to be
All right.
able to say to do it
Well,
by then, if we have to do the
If
briefing.
no one's going to scream if it gets put off till March, that's okay. I like to give you the opportunity to have these things decided as quickly as we can, but this is going to be a complicated one.
You have a week to tell us whether you can do it by the 7th.
Well, I mean, we can set up the scheduling order fast enough. It's just, I think, especially for opposing counsel, if you contemplate a 30-day deadline for us and then another 15-day or 20-day deadline or something for opposing counsel, that by itself is already at Christmas. And if it's two
And
30
then it
days, then we're at the
applies
7th.
for,
Okay,
yeah.
all right.
Yeah.
All right, that's what we'll do then. So get us your suggested language, agree on the record, and tell us what it is. So we have, it'd be nice to have a nice package of exhibits that had the record in it. And for people to have enough time to review that before the next substantive hearing. So, are we good?
So we're back open for
Yeah,
January?
We're back
Okay.
open for January. All right, thank you both very much. Thank you, Mr. Goldstein.
Thank you.
Thank you, sir.
I'm going to stay up here because I have another one.
Yes, you do.
I'm a little bit confused with that. A little bit confused with the schedule. Nothing June, January.
No. They're going to send us proposed language for the scheduling order in a week, and then I'll get something to you to send out that'll lay out the rest of the scheduling.
Well, this is not, this is not the original application. I didn't print it because it's so short. This is a supplemental filing, but it gives the history of the plans.
Yeah, I think you did enter mine for your.
All right, folks, if I don't get my board out here close to 9, they get grumpy.
Nobody's listening.
No one pays any attention.
Shoot me an email, and then we can connect on everything.
All right, we're going to call the next case. Status conference. We have an appeal number in this one yet, Kim? It's an appeal by Stephen and Julie Anderson challenging a decision of the director to deny their application for a permit to demolish a residence at 305 State Street in order to build a new residence. This matter was originally scheduled for a status conference in October, but was rescheduled for the convenience of the appellants. We have Ms. Corrace again for the director, and for the appellants, is it Ms. Baldwin?
Yes, good evening, Sally Baldwin.
Thank you, Ms. Baldwin. So let's turn to the record. Do we have a certified record yet?
We do not.
Okay.
And I think that's what we needed to figure out the deadlines for that record and any objections, and then our response to any objections.
Ms. Baldwin, you heard my discussion in the previous case about what the record should include.
I did. We submitted a letter
You did. I got
indicating what
four.
we'd like to have supplemented to it, and we understand that
Yeah.
that's the process we're going through now.
So, yeah, tell Jessica what you need and why, and the director will decide whether that's part of the record or not.
Understood. If there's any issues that we disagree upon, whether something should or should not be in the record, how's that handled?
Bring that back to the board. We encourage you to avoid that. I mean, the only circumstances I can see where we would get to that would be if, well, if there was something that you thought they had considered and were hiding.
I understand. There's a few different categories of documents and things that we would like to supplement the record with. Most of those are public record. Some of them are communications. And I understand from the city that they have an issue with that, but they're the communications with the staff that made the decision. So I know we're going to have at least one item that we disagree upon. As well, I'd like to have witness testimony as well. There hasn't been a hearing on this matter at all, so
No,
they haven't been given the opportunity.
I don't think there's going to be, I mean, you've got the denial and the staff reports behind the denial. They say they relied on that. it appears from the staff report, I mean, you can ask if it's the case, that much of what's in the staff report is based on the observations of staff in the neighborhood. Photos, description of what staff saw. If that came from some other source, then that's obviously something they relied on. That ought to be part of the record. But that seemed like where a lot of it was. If there's a manual published by the Association of Historical Preservation Professionals that said how you determine whether something is historically significant, and that's not in the record, that would be fair to ask, didn't you look at that? But I think if there was such a thing, they would certainly want it in the record.
Understood. I feel like these two items that we're talking about, though, are slightly different than that. I understand that analysis for the public records and things like that that we're seeking to have introduced. But the email communications with the people making the decision, the city staff that was making the decision, their email communications with the person applying for the permit are certainly
all right.
relevant.
Well, that gets me to another point. So what you may be referring to is, did they know about the conversations earlier with Mr. Tower, was it?
He's one of the staff members, yes.
Yeah, and I think you alleged somewhere that Tower at some earlier point said this wasn't going to be a problem. If the board were to find that there was an adequate basis for the director's decision that this property is historically significant, would you be asking us nevertheless to require that a demolition permit be approved because Mr. Tower had made a mistake in telling you that there was no problem earlier?
That wouldn't be the only basis for it, but what that really goes to is the heart of the issue, as also why I'd like to have the opportunity for additional witness testimony, is because it's a matter of due process. There was never a time that the applicants were able to have any sort of dialogue or present their side.
Where is that required in the code?
If there's a finding that the property may be significant, there's an opportunity in the code for there to be an optional public hearing on that. That public hearing never occurred, so there has been no hearing at all.
Well, isn't that an argument that the decision was arbitrary and capricious?
It's part of it, but if the applicant is being, is understanding that this is not a significant property because that's what he's being told, and then the decision comes out without any other back and forth, he's not able to rebut or respond to any of the assertions in the staff report that are incorrect. They're based on factual errors that can be verified with public records. If they're not able to see that that's what is happening here, they don't have the opportunity to respond. They don't have the opportunity to rebut. They've never had the opportunity for their side to be heard. And now the record is being limited only to the things that the director decided to use in their decision without ever hearing from the applicant. That's the issue here. So they didn't have the opportunity for the public hearing. They haven't had the opportunity to rebut anything. And now they're in a position where they're not able to offer testimony. And
It sounds like you're asking for discovery, and there is no discovery in these cases.
I think that the board does have the ability and the power to do anything that the director could have done. And the director could have asked for this public hearing, but did not, and gave no indication to the applicant that the property would be found significant. In fact, they said it wasn't. And so the applicant had no indication to push for it either. So it just never happened. So this is now an appeal on a hearing that has never occurred.
Well, when you decide what witnesses you think you need and why, make your proffer and we'll decide. But we're going to be very reluctant to have fact hearings.
When is the opportunity to proffer this and this decision made?
Well, we have to talk about that. That's the scheduling question. What due process rights were denied?
For the applicant to have their side heard. They had a decision that was made.
And the origin for that right is the section you referred to that says if there is if it's going to be.
If the property is found to be significant, then there is the opportunity. Basically, it's saying if there's going to be
It's a
any-
may, isn't that a may, not a shall?
Yes, but it's if the property is found to be significant. Here, the applicant is corresponding, and just to give a little bit more context, they were in the process of the site design plan review. Normally, they would be getting a determination on that, and after that, they move forward to seek the permits. Here, they were never given a determination in the site design plan review. They still don't have it. They were told instead to stop in the middle and apply for a demolition permit, which they did. They listened to what they were told to do, and then they were given no opportunity to provide their arguments. And there was a decision made on behalf of the city that relies on the staff reports that have factual errors in them, and they've never been given the opportunity to say their side. And now the record is limited to just what the director considered, which is wrong, and they haven't had the opportunity to present their side, to present a witness, to give any type of information that should have been considered. The decision was made without the opportunity for a hearing, without any indication that this was going to be something contentious, and they receive a denial, which is, again, of a permit before they've even gotten through the site design review process. So procedurally, there's some issues there, but what the end result is that there's a denial of due process for the applicant, because they're only now allowed to rely on the things that the city relied on, and that's what our argument is that they weren't given the opportunity to present their side. They weren't given the opportunity to present a witness, testimony, other information to correct the factual
But
errors.
you don't need their emails to argue that they weren't given the opportunity, right?
I think that the emails inform why the decision was made with the time frame that it was, that the process was handled the way that it was. This was not the normal or understood procedure that you get a site design plan review decision and then you move on to the permits. Instead, something different happened here. They were asked to get a permit in the middle, not given the opportunity to present any witnesses or any information until they got this denial after being told that this is not a significant property. So they've had no opportunity to present their case.
Do you have a question, Christian?
I'm just hung up on this point of the lack of opportunity, or the application process in and among itself is the opportunity to present qualifications substantiating the right to demolish. Is that not true?
That's true, but they're not given the opportunity to present the witness, their architect, the design.
So the planning department
information.
only relied upon the information that the applicant included within their demolition application.
I think that's one part of it, because again, they're in the middle of the site design plan review when they're asked to get this permit. This permit would normally be made after that type of review has already gone through the process, where they've been able to present that type of information. Here, they weren't.
We don't know why, unless you tend to enter into evidence where it's on the record, why that request was made. You can do that later. You can tell us later why that request was made. But the contention that they were denied an opportunity to present facts regarding the demolition, the circumstances surrounding the right to demolish is considered within the application process.
Part of our argument is that we have presented, through the application process, they presented certain information about the property, and the decision was made on things outside of that that are actually errors. So they were never given the opportunity to rebut that.
All right, so it looks like we need to set a deadline for you guys to agree or disagree on what the record is. Right. So what would you suggest? Jessica, do you need time to, you should make a proposal back to Ms. Baldwin.
I would ask for 2 weeks to be able to put the record together, so the 20th.
Okay. Ms. Baldwin, how long would you need to?
I was gonna just say a week, but 2 weeks is also fine.
Okay, so that would be, you're getting this, Kim, the 20th for Jessica, and that would be December what?
27th are the objections, is that what you mean? Or do you want 2 weeks to respond?
2 weeks, she said.
So you're saying that you're gonna have yours by November 20th?
On the 20th, yeah. So
Okay.
when do you want to submit your objections by?
2 weeks after that?
December 4th.
Okay.
And then are we doing, I think in the past, there's been another deadline for the director to respond to the objections?
Yeah, let's see if, do we have a December meeting?
It's the 3rd.
We can, do you have anything coming up?
I'm on the bubble right now.
So are we.
I'll know the week.
Yeah, so, yeah, it's pretty iffy for both of
Is
us
the
to have
capital,
something.
no, capital stuff's off the table.
Yeah.
Is
It was mainly the appeals, I think, in
Is
December.
Athens, that one needs.
Is Athens up on December 3rd?
That's a you, that's not us.
Yeah, that's true.
Do you know if that's the same?
That is.
I forget when we scheduled that.
Currently, it's 2 variances.
What's on,
Do
for?
the new rules here.
On December. Oh, so we are going to have a December meeting.
What's on there, Kim?
The variance, 2 variances, Dewey Drive and Shiloh Street.
Oh.
Those are still up in the air. They were just space holders. They're not definite yet.
But we definitely have the rules.
Public hearing on the new rules.
So let's compress this a little bit so we can hear your response in the form of an argument on December 3rd. So let's move you back a couple days and move Ms. Baldwin back a couple days.
Okay, so you want to change the deadline for the record?
Let's give you till the 18th and give Ms. Baldwin to the 2nd.
Okay, and then on December 4th is going to be,
December 3rd,
December 3rd is a hearing on everything or
On the
just-
record.
Or just on the record?
just on the record.
Okay.
To see if there are any problems to work out.
Okay.
And then
So
we will,
just so I'm clear, the hearing on the 3rd is the evidentiary hearing?
the hearing on the 3rd will be hearing any objections that you have to the director's final determination of the record after hearing your suggestions.
Okay, so objections and supplements to it, that's all included in that hearing?
Yes.
Got it, thank
Right.
you.
And then from there, we'll set the hearing on the larger issues. I would encourage both of you to take seriously Mr. Meekin's suggestion, director's suggestion, considering if there are ways to modify what you want to do that accommodate the interests of the city and your clients.
I understand.
Okay, good.
One other issue that just occurred to me is that we made PIA requests to get the information regarding this property, and we haven't received that back yet. I think the 30th day would be November
We
18th.
mailed that certified mail to your office last Friday.
Okay.
So
We
make
haven't
sure,
received it.
tell me if you didn't get it, but we
Yeah,
sent
we
you a
have
thumb
not.
drive.
A thumb drive?
Yeah.
Okay,
Don't-
as of today, we haven't received it.
Okay.
We don't decide PIA cases.
Yeah.
I'm just saying, we
yeah.
wouldn't have any opportunity to talk about the records if we haven't received them yet.
Well-
We asked to view the zoning
Well-
file, and we were told we had to do a PIA request, so we haven't even seen the zoning file here.
She said she sent them to you, I'm sure she did. Yeah.
Just double check. If you didn't, we can
Yeah.
resend them, but we put them on a thumb drive and mailed it on Friday.
Got it.
Anything I've missed, board members, council? No? Okay. All right, that's good then, we'll see you in a month.
Thank you.
Thank you.
Thanks very much. All right, other business. I circulated to you all months ago the rules revisions that I think we need to accommodate the new standard operating procedure for virtual meetings and appearances. I think you were all signed off on that. So they're now up on the website.
IT was supposed to do it yesterday, and we still haven't, so I'm following up again.
Okay, they will be up on
In the
the,
next day or so.
they'll be up on the website shortly. Well, here's the way it goes. They'll be on our agenda for the December meeting. So public notice will be through the agenda, and it's already up on the website. Thank you, Jessica.
Thank you.
Right, and then we won't vote on it until the January meeting. So that gives the public a month to comment. I'm sure the alderman from Ward 8 will have lots of comments.
RHA the third.
All right, anything else?
Hearing none.
I think that's it.
Motion adjourned.
Second. All in favor?
Aye.
Thank you, guys.
November 2nd.
Of the what?
Oh, let me pull that up again. They haven't been posted. These are drafts that we're working on.
You're going to miss that? That's intentional.
But I didn't know that. Mike had penciled them in.
Oh,
just
good
as a
for you.
Placeholder in the calendar.
You got some show tickets?
Those two are not,
No.
the variances are not going to second.
Okay,
Yes, sir?
good for you.
Yes, we are adjourned?
Yes.
Yes.